What do you think, Lord Denning, about the problems that arise when Parliament tries to prevent the courts from exercising their powers of judicial review? For example, when they put a clause in an Act of Parliament about some tribunal saying that what it decides shall not be questioned in any court of law.
We've had this question from the very beginning. Parliament has tried from time to time to oust the jurisdiction of the courts. There was a clause, I think Lord Hewitt condemned it in his New Despotism, whereby the ministers were given the power to alter or vary legislation by their own regulations. And that was condemned by then. But we've had many cases since. The first one, which I remember, is when they said the decision of a medical appeal tribunal was to be final. We had a case where a man he'd lost one eye and he then lost the other. The medical appeal tribunal only allowed him 20% for his pension, whereas really, as we read the regulations and everything like that, he ought to have had a full pension for blind in both eyes. Well, the minister said his decision was final. Parliament has said his decision was final. We got round that all right. We only said that meant final without appeal. It didn't stop us by our own jurisdiction of certiorari, of our own writs of coming in. So we overruled that minister and said, well, final didn't mean final, so far as the courts were concerned. That was the first one I remember. Then they had provisions in which they said, and there were several on this, the decision of the minister or a tribunal shall not be questioned in any court. That's difficult to get round, you know. And I don't know whether you would remember it as well as anyone. Wasn't that, in a way, that great Anna's Minute case? Was that the one?
Yes, exactly. That was where the Foreign Compensation Tribunal had rejected a claim arising out of the Suez affair, the invasion of the Suez Canal, and it was contended that they had misconstrued the law under which they were supposed to make the awards, so that it was really a mistake of law. Now, how did that fit into the picture, do you think?
Well, now, I remember that case well, because it came before me at an early stage when the tribunal, or rather the government on behalf of the tribunal, said, well, there's this section of an act in Parliament, and said the decision as to compensation, they'd refused it, shouldn't be questioned in any court of law whatever. And they got forward some argument, I thought a good argument. I said, we're not going to strike this claim out. It may have some foundation. We may be able to get round that clause. I didn't sit in the Court of Appeal in that case. I don't know quite why. Perhaps I had something else on. But the Court of Appeal then said, I think by majority, but then said, at all events, fine, it was not to be questioned in any court. We went by the little, and I think Lord Diplock was one of those then, but still it went to the House of Lords, and that is really a most important case. The error, as you mentioned, was as to the construction of some regulation or other, or some order in council, but they said, although that was the construction, it was an error which took them outside their jurisdiction altogether. And I think I said a little while ago, the courts have always had power to interfere when a body goes outside its jurisdiction, not when it merely goes wrong within its jurisdiction. That's the distinction which we always took in the old days. Well, in this particular case, the House of Lords said this error was one which took it outside its jurisdiction, and despite that clause in the Act of Parliament, it could be questioned in the courts and was questioned because there was an error outside their jurisdiction. But they had all sorts of different views. It was a right decision, mark you, entirely right in this way. I don't think Parliament ought to be allowed to stop access to the courts. And here the House of Lords managed to get access to the courts and put the thing right. But there, I must say, if you read those judgments, they're very long and contemplated, people each giving different views. It's a bit difficult to get head or tail of it. But we had it on later ourselves, and we had to try and make head or tail of it.
Perhaps we should go back in history before we go forward. Don't you think the House of Lords were doing what the judges have in fact been doing since the 17th century, when they had to deal with other authorities, magistrates, for example, and they took the line that these clauses in Acts of Parliament had a genuine purpose in preventing the magistrates being upset for some trivial little error, which might be merely an error on the face of their record, as it was called in those days, but that Parliament never had the slightest intention of allowing them to do anything they liked by going right outside their own jurisdiction. Wasn't that the old tradition which the House of Lords was simply affirming in the Annis Minute case?
I would like to think that, but I looked at it all in that earlier case, Northumberland Conversation and so on, so on. I'd like to think that the House of Lords were going back to the good old times when judges could interfere and weren't interfered with by Act of Parliament like that. But at all events, what I was saying at the moment, it was difficult for lower courts to pick out the real ratio decidendi from the speeches in the House of Lords, most important as they were. But that came up for consideration in later cases, in both of which I was concerned about tribunals, where they'd gone wrong in point of law.
One of them was the Perlman case, wasn't it? About the great question whether central heating is a structural improvement to a house. If you install central heating, is that a structural improvement? And it was enacted under the Housing Act, I think, that the tenant could go to the court and claim the benefit for purposes of leasehold enfranchisement if he put in central heating by getting the maximum value reduced to within the statutory limit. But Parliament itself had then cut off any further right of appeal, so that if the tenant didn't get a right decision from the county court, it couldn't go up on appeal and be put right. So it seemed that what was intended to be for the benefit of tenants was actually working against them by cutting off their legal right of appeal.
Yes, well, now I remember that case perfectly well. It was just on the meaning of those words, structural alteration, so much depended, and it went before the county court judges. One county court judge would decide one way, and one county court judge would decide another way. And that seemed to me all wrong, on the same Act of Parliament, but there was no appeal from it, or no way of recourse to the courts upon it. And then I don't know whether I chanced my arm or whatever it was, I said that if a tribunal makes a wrong decision on a point of law, it goes outside its jurisdiction because it has no jurisdiction to go wrong. It has no jurisdiction to go wrong in point of law. And I remember I looked up those speeches in the House of Lords. I got one little bit from one speech, one little bit from another, and I managed to say that if a tribunal goes wrong in point of law, it goes outside its jurisdiction altogether. I remember the present Lord Chief Justice, Lord Lane, didn't agree with me on that. But there was no appeal on that, and we won on that ground. But then we had another case, a similar sort of thing, but it was from a high court. It was all about looking at some accompanying documents and things like that. You needn't trouble about the details. But the judge of the High Court had said, as he read the statute, there was no power to inspect these documents. Well, we read it differently. And I said we could interfere with that error of law, but the statute had said it shall not be appealable. And that case went to the House of Lords. It's called Re Cal Company. And it was very interesting. Lord Diplock said we were wrong in interfering with the High Court because it was said to be member. But he went on to enunciate and approve our broad principle, which I mentioned in that Pearlberg case, drawing on the Anaminic. He said an error of law. If they go wrong in law, they go outside their jurisdiction, and we could interfere whatever an Act of Parliament said. And it was that dictum, really, which led the way, and is, I think, absolutely right. It means that whatever Parliament says, they said, oh, it shan't be appealable, it should be final, the courts shan't be questioned in the courts. They may say all those things. We get round it every time by saying, well, if they make an error of law, they go outside their jurisdiction, we can interfere whatever Parliament says. So we won the day in the long run.
That was repeating what Lord Diplock had said in a public lecture a few years before.
At your university, I think, Professor.
At Cambridge. And I've often thought since how nice it must be to be able to say something in a lecture and then uphold it in a speech, in a judgment in the House of Lords. It makes an academic rather envious.
Oh, yes, but people don't take much notice of what I say in lectures, but I took notice of that, and that helped me in coming to the view which I expressed. And I was very glad that Lord Diplock afterwards it made it quite clear, it's the most important thing, that an error of law deprives the tribunal of any jurisdiction in the case, and the courts can interfere.
But that's going a long jump further than the House of Lords thought they were going in the Anaminic case, because they thought there that they were sticking to the old distinction between what was inside jurisdiction and outside jurisdiction. But in the way they applied it, they seemed to knock the bottom out of it, because they held that a mere misconstruction on a point of law, getting the meaning of those regulations wrong, was in fact an error which went outside jurisdiction. So that seems really, while on the one hand purporting to uphold the old principle, on the other hand to abolish it.
Well, you put it right. That's where the professors come into their proper sphere, Professor, in this way, that there you pointed out that in practice it was, whatever they said, it was an error of law and nothing more. And nevertheless, they interfered. Now, that is, I think, most valuable line, in which I may say so. The professors helped to show the way.
Now, here's another professorial comment. In the old days when the judges worked out their distinction, they could at least say that they were obeying the Act of Parliament in cases where the error was within jurisdiction. And there were many of those cases in the way the law then worked. And they only jibbed at applying it when the tribunal was clearly going right outside its jurisdiction. But under the doctrine that you and Lord Diplock have now put forward, there are no circumstances in which the courts will obey the Act of Parliament, because if every single mistake of law involves an excessive jurisdiction, then there is no case where the ouster clause can have any effect. Now, aren't you really saying that the courts have gone into rebellion against the Act of Parliament and are not going to have anything to do with it?
Well, we never say we're in rebellion. We always get round it. We always pay subservience by our lip service to what Parliament says. But if Parliament, we say, oh yes, we obey Parliament. But in the cases where justice requires it, we've got all sorts of ways of getting round such a prohibition or ouster of the courts.
Well, isn't it almost like saying that we've got a sort of fundamental right in our Constitution? There's one thing that Parliament can't take away, whatever words it uses, and that is the right of the citizen to go to the court and have an error of law put right.
Well, I very much like your way of putting it. That is very fundamental. Whatever Parliament may say, it can't take away the right of the ordinary citizen to come to the courts to see that the law is obeyed and is enforced. I'd like to think it's that way, but we never put it that way, the judges. We never say we go against the intention of Parliament. We pay lip service by saying we obey the intention of Parliament. We've got all sorts of ways of getting around it by reference to what you've put it as a fundamental principle, unwritten in our Constitution.
Then we shall have to change what we teach students in their first-year constitutional law, that the judges in this country always obey the intention of Parliament.
Well, teach it if you please, but let it be said we always obey the intention of Parliament, but got ways and means of getting round it if Parliament does what we think is contrary to constitutional principle.
I think you said something like this in your Dimbleby lecture on television, when you said that it might almost be an abuse of power for Parliament to pass acts of certain kinds, and may it not be something like that when Parliament tries to stop the judges doing their job, doing what they are there to do, that is to say, deciding questions of law between subject and subject.
Well, I borrowed from you, Professor Wade, when you gave some Hamlin lectures, and I remember I took as an illustration. Suppose that it took upon itself to abolish the House of Lords, if you please. I think the judges might well say this is contrary to our Constitution. Whatever that Act of Parliament said, the judges could interfere and say that's unconstitutional. I'm pretty well sure that, but I would say it. If Parliament were to get it all through its stages by appointing new peers or thousands of peers, as Mr. Ben wanted, if they were to try and get through an Act of Parliament abolishing the House of Lords, I say that it's unconstitutional. I hope every judge in the land would say it's unconstitutional. You can't abolish the House of Lords like that.
I'd like to lead you into a longer discussion about constitutional law, but ought we perhaps to try and sum up the situation about ousting the jurisdiction of the court? The Privy Council decided a case just within a fortnight, I think, of the Rakow case in which you took the leading part, when they held that the old distinction still worked and they refused to obey the clause ousting the jurisdiction of the court. That was a labor tribunal in Malaysia. So there we've got the House of Lords and your view in the Court of Appeal saying one thing and the Privy Council saying exactly the opposite.
Well, that very rarely happens. I think one hand can't have known what the other hand was doing there, what the Privy Council was saying. But the judges are very nervous about saying that jurisdiction is done away with, that distinction is done away with. I think it has been done away with, but you'll find the judges again reluctant to say so in terms. They still keep the old distinction in practice, but I hope the time will come, and not long, in which it will be said that what was said in the Malaysia case was erroneous, and that any error of law, this is what it comes to, if a tribunal makes an error of law at all, it goes outside its jurisdiction, and whatever Parliament or the legislature have said, the courts can inquire into it and put it right.